Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. In litigation, as in life, sometimes you have to be careful what you wish for, because sometimes you get what you wish for, and it turns out not to be what you should have wished for. And this is a good example today in this case, which involves the setting aside of a default judgment. And the reason the judgment gets set aside we'll go into in a minute, but essentially what happens, the TLDR, if you will, is this. The person who is sues, gets a default judgment, and then because she's suing multiple people, the second case goes to trial, and they get a judgment that's inconsistent with the default judgment, and she loses the default judgment. This is the case of Laura Henry versus Olakunle Olawale, who is a doctor in the state of Connecticut. And this is an opinion from the Second Circuit U.S. Court of Appeals. So, defendant Olakunle Olawale appeals from the entry of a default judgment in the U.S. District Court for the District of Connecticut, awarding $100,000 in non-economic damages in favor of plaintiff appellee Laura Henry. So what does it mean when a lawyer says non-economic damages? Non-economic damages are damages for things that you really can't replace with a checkbook, and for which there is no real economic substitute. Now, for things like cutting the lawn and doing other services around the house, you can go and get wages for a handyman, and that would be an appropriate economic model. But here, for things like pain, suffering, humiliation, loss of enjoyment of life, and other emotional type injuries, there really is no economic model you can use. So it's up to the discretion of the jury in most cases. I would point out that most of the time in most states, non-economic injuries are capped as to how much a jury can award, and a jury is never told up front what that cap is. In fact, it would be an ethical violation for a lawyer to mention that during trial. Henry filed suit against Olawale and their former employer, Bristol Hospital, alleging that Olawale had assaulted her. Shortly after Henry filed her complaint, Olawale was seriously injured in a motorcycle accident, and he maintains that the circumstances of his recovery prevented him from receiving timely notice of the action. Olawale did not initially appear, and the district court entered judgment against him. Default judgment against him. 5 years after Henry filed suit, Olawale entered an appearance. He moved to set aside the default judgment, but the court denied his motion. The case against Bristol then went to trial, and the jury found that Henry had failed to prove that Olawale had assaulted her. Following the jury verdict, the district court vacated the default judgment against Olawale as to Henry's assault and battery claims because those claims were inconsistent with the jury verdict, but left in place the default judgment as to several other claims. On appeal, Olawale argues the district court erred when it denied his motions to set aside the default judgment. We agree. The district court should have set aside the default judgment pursuant to the factors set forth in Enron Oil versus Diakuhara. Let's look at the Enron factors from that case right now. So here is the process for entering a default judgment. Rule 55 says that a clerk may enter a default upon being advised by affidavit or otherwise that a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend. The clerk's record should contain a notation to that effect. Rule 55B provides that judgment by default may be entered as follows. The clerk may enter a judgment when the claim is one for a sum certain, if furnished with an affidavit of the amount due, and provided that defendant has been defaulted for failure to appear. In any other case other than a sum certain, application must be made to the court for the default judgment. The defendant, if he or she has appeared, is entitled to 3 days written notice prior to the hearing. If in order to enter a default judgment the amount of damages must be ascertained, the court may conduct a hearing to basically determine what those damages are. After default or a default judgment has been entered, Rule 55C grants the litigant the right to petition to set it aside. A party may move pursuant to Rule 55C to set aside for good cause or to set aside a default judgment in accordance with Rule 60, again for good cause. The disposition of motions for entries of defaults and default judgments and relief from the same are left to the sound discretion of the district court, because it is in the best position to assess the individual circumstances of a given case and evaluate the credibility and good faith of the parties. Such discretion is nonetheless not unlimited. We have reversed its exercise even when the abuse was not glaring. The circumscribed scope of the district court's discretion in the context of a default is a reflection of our oft-stated preference for resolving disputes on the merits. We recognize that a tension exists between the push on the court to dispose of cases and the desire of the trial court to do justice in an individual case. But an understandable zeal for a tidy and reduced calendar shouldn't overcome a court's duty to do justice. It's the responsibility of the trial court to maintain a balance between clearing its calendar and affording litigants a reasonable chance to be heard. With these general principles in mind, we turn to the substantive rules for setting aside a default or default judgment. For good cause shown, the court may set aside an entry of default, and if a judgment by default has been entered, may likewise set it aside in accordance with Rule 60. Because Rule 55 doesn't define good cause, they came up with three factors. They are whether the default was willful, whether setting aside the default would prejudice the adversary, and whether a meritorious defense is presented. In addition to those, other relevant equitable factors, or fairness factors, may also be considered. For instance, when the failure to follow a rule or procedure was a mistake made in good faith, and whether the entry of default would bring about a harsh or unfair result, which I think is what they're aiming at in this case. And so the court recognizes that the factors are the same for a default or a default judgment, but they're applied more carefully with respect to a default judgment because the concepts of finality and litigation repose are more deeply implicated in the latter action. Further concerns regarding the protection of a litigant's rights are heightened when the party held in default appears pro se. A party appearing without counsel is afforded extra leeway in meeting the procedural rules governing litigation, and trial judges must make some effort to protect a party so appearing from waiving a right to be heard because of his or her lack of legal knowledge. Hence, a general rule, a district court should grant a default judgment sparingly and grant leave to set aside the entry of default freely. Finally, they slap the district court upside the head for not providing an explanation. The importance of an explanation by the district court for its denial of a motion to vacate in light of these criteria is self-evident. The absence of an explanation defeats intelligent appellate review. While the failure of a district judge to provide an explanation is not always fatal, so long as it's possible to discern the appropriate criteria have been satisfied, it remains true that a trial court should provide specific reasons for a denial of a motion to set aside a default under Rule 55C. And following the jury verdict, the district court should have vacated the entire default judgment as inconsistent with the verdict pursuant to the principle set forth in Frau v. Della Vega. Accordingly, we reverse the judgment of the district court and remand with instructions to enter judgment for Olowol. And they note Judge Kersey dissents in a separate opinion, and oh boy, does he dissent, and he brings the receipts with him. So we'll look at that here in a moment as well. Here's the background. Defendant appellant Olakunle Olowol appeals. Basically, Laura Henry in 2013 filed suit against him and Bristol Hospital alleging that he had assaulted her. Henry asserts claims against Olowol for assault, battery, false imprisonment, intentional infliction of emotional distress. You'll see that abbreviated in the opinion as IIED. Negligent infliction of emotional distress. You'll see that abbreviated as NIED, and negligence. But shortly after Henry filed her complaint, Olowol was seriously injured in a motorcycle accident. You find out later in the opinion that it was a brain injury, as often happens in motorcycle accidents. And he maintains that the length and circumstances of his recovery from the accident prevented him from receiving timely notice of the action. Olowol did not initially appear. The district court entered a default judgment against him as to liability, but not as to damages. 5 years after the Henry filed suit and after Bristol had proceeded to discovery and filed a motion for summary judgment, Olowol entered an appearance. He moved to set aside the default judgment, but the district court denied his motion. Now let me lay out the timeline in this case so you can sort of understand where all this sort of fell out and how long the differences were in the time. In June of 2011, the encounter in the office is what started the case. And then in June of 2013, Henry filed suit and a summons was issued. And then in October, he had a motorcycle crash where he was brain injured. Thereafter, in April of 2014, he was served and a summons was filed with the court. In February, she moved for default judgment. And then in September of 2015, that judgment was entered. And then, 3 years later, in August of 2018, Olawole moved to set aside the default judgment, which was denied by the district court in May of the following year. The case against Bristol then proceeded to trial. The jury returned a verdict in favor of Bristol, finding that Henry had failed to prove that Olawole assaulted her or battered her. Following the jury verdict, the district court vacated the default judgment against Olawole as to the assault and battery claims, but left in place the default as to the other claims. The district court then held hearings on damages and declined to award economic damages and punitive damages to Henry, but it entered a final judgment ordering Olawole to pay $100,000 in non-economic damages to Henry. And we agree with Olawole that the district court basically made a mistake here. The court's standard of review says we review the denial of a motion to set aside entry of a default judgment or a default for abuse of discretion. We review the findings of a district court in connection with the damages award for clear error. Olawole argues the district court erred both times it denied his motions to set aside the default judgment. We agree. The district court erred when it denied the initial motion to set aside the judgment pursuant to the Enron oil factors. The district court erred again following the jury verdict in favor of Bristol. It vacated the default judgment as to Olawole with respect to the assault and battery claims, but not the false imprisonment, IEED, NIED, and negligence claims. The district court abused its discretion when it first denied the motion to set aside the default judgment. Although our standard of review is deferential, the district court's discretion is circumscribed because defaults are generally disfavored and reserved for rare occasions when doubt exists. A default should be granted or vacated. The doubt should be resolved in favor of the defaulting party. Because of the policy of favoring judgments on the merits, a glaring abuse of discretion is not required for reversal of a court's refusal to relieve a party of a harsh sanction of default. So that's exactly what they did here. And this brings me to Judge Kersey's dissent. Now, dissents do not have any precedential value in terms of being authoritative, but they can sometimes lend a little bit of explanation and provide someone who might be opposing one of these motions later on a little bit of ammunition to attack the soundness of a decision that you disagree with. And so that's what Judge Kersey does for defense attorneys here in his dissent, and he does it very well. Let's take a look. He says, I respectfully dissent from the majority's ruling that the district court in this case abused its discretion in declining to vacate so much of the entry of default and the non-final default judgment as held defendant Olawole liable on plaintiff Henry's claims of false imprisonment and intentional infliction of emotional distress. Given the record showing A, that Olawole was in default for some 5 years before appearing in the action, B, that his motion to vacate the default initially proffered the excuse that he had been disabled and hospitalized, but without support by any evidence, not even a sworn statement by Olawole. And one of the things that is true always is that motions are not self-proving. Just because you say something in a motion doesn't mean that the court is going to believe it if you don't offer some form of sworn testimony. So that's what they're talking about there. That Olawole's next proffered excuse that he had not learned of this in 2013 until 2017 was stated in affidavits from Olawole and his wife that were short-lived, being quickly withdrawn when Henry produced a message that she had received from Olawole in 2015 referring to his not facing her in court, and D, that during the 5 years prior to any attempt by Olawole to appear in the action, at least 2 of Henry's potential witnesses had died. I disagree with both the majority's disregard for the record as to the willfulness of Olawole's default and its view that the district court could not properly find that Henry had been prejudiced by Olawole's delay. I also disagree with the majority's ruling that the complaint failed to state a cause of action for false imprisonment and intentional infliction of emotional distress. And from that point forward, he goes on to talk about the rule and why he believes that they've made an incorrect determination here. But really, in terms of providing facts for a quick read and understanding why he dissents, he couldn't have done much better than what he did in that introduction there. You had somebody essentially who made the motion without providing any evidence, and then when he did provide evidence, it was false evidence. And so you can understand where the district court might have been more than a little peeved at him and his counsel for attempting to put into evidence things that simply were not true. And so that's one of those things that I believe probably contributed to his dissent, is the fact that he thought this guy was lying about his disability. I'm amazed that the 5-year gap in this case was not something that motivated the court to leave the judgment in place. And if that wasn't enough, if the 5 years wasn't enough, then I'm having a lot of trouble with the fact that they offered false evidence. Now, part of that may be because, they were pro se litigants at some point. I don't know. But it doesn't excuse offering a false evidence and false excuses that you support with motions that are under penalty of perjury. At any rate, that's what I have for you today. Thank you so much for watching. If you have any comments, drop them in the comments down below. Like, share, subscribe, all that stuff. You can email me if you have any questions. And again, if you have the opportunity today, do something nice for somebody, and then come on back tomorrow. Join me down here at the beach. We'll talk about something else that'll be fun and interesting. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.